Hey everybody, it's Andrew Gross of the Law Office of Andrew P. Gross. We do VA disability benefits appeals for veterans of the United States military, no matter where they are in the world. And we also do estate planning for veterans and their family members, or with a focus on veterans and their family members in DC and Maryland. Today in today's thought of the day, I want to talk about Arellano v. McDonough. It's not often that the Supreme Court comes down and rules on a case dealing with veterans. Recently, they've done two, and I haven't done a video for the other one, but today I want to talk about the most recent one. It only came down this week. It's Arellano v. McDonough. And if you read the headlines out there, people are thinking it's terrible for veterans. But quite frankly, I thought it was a bit of a long shot in the first place. And judging by the 9-0 ruling by the Supreme Court, a unanimous ruling by the Supreme Court, by the way. So the Supreme Court ruled unanimously on this. It did not go in the favor of the veteran. So here's the backstory. It deals with a concept called equitable tolling. All right. So equitable tolling deals with another concept called statutes of limitations. Right. So a statute of limitations is the time period with which you have to take a certain action. Right. So if you have let's say a car accident case in Maryland, you have, generally speaking, 3 years from the date of the accident to file a claim against the person who hurt you. In this case, veterans have statute of limitations too when it comes to VA disability benefits claims. For instance, if you get a decision you do not like, a rating decision, you, generally speaking, have 1 year from the date of the decision to appeal it, or else it becomes final, and then you can only reopen it and your effective date gets lost. Generally speaking, there are exceptions to this rule. I'm only providing it as illustration. Equitable tolling says, well, there were factors outside of my control that prevented me from taking action, and those shouldn't be held against me, right? Equitable tolling might be something like the VA gives you bad information, or you were in a coma and you literally could not file a VA disability benefits application. In the Arellano case, we have a case where it's rather unfortunate. The veteran was discharged in 1977 and suffered from a number of psychiatric conditions. It wasn't until 2011 that the veteran actually filed his application for disability compensation, which was ultimately granted. And he wanted an earlier effective date that went all the way back to 1977. But he never filed a claim in 1977. That's the problem. The veteran argued that equitable tolling, mainly his condition, his service-connected condition, is what actually prevented him from filing a claim. And the Supreme Court said, tough. There's a statute. There's nothing in the statute that says that time period can be equitably tolled because of the veteran's condition. So the effective date is the date of the initial filing of a claim. Now, there are some things that can be equitably tolled under certain circumstances. For instance, if you have a claim that you want to appeal to the Court of Appeals for Veterans Claims, CAVC or CAVIC, you have 120 days from a Board of Veterans Appeals decision. Sometimes that can be equitably tolled, meaning that if there's some sort of crazy issue that's preventing you from filing that notice of appeal, you can actually request equitable tolling. But in this case, the Supreme Court said, hey, for initial applications, the section of the statute has no provision in it to allow for tolling. And the statute is 38 U.S.C. 51-5110B1 and deals with equitable tolling of that time period to file an initial claim. So with that said, disappointing result for veterans, but it underscores a couple of very important lessons here. The lessons are, if you have a disability, file it or file an intent to file. Stay on top of it. Don't miss deadlines. If you disagree with the decision, reach out to someone to help you appeal it as soon as possible. Don't wait until long after service to apply for disability benefits. If something's wrong and you're getting out of the service, apply and appeal until the VA gets it right. Don't wait. The longer you wait, the more likely it is that the statute of limitations will pass and you won't like the effective date they give you. For many veterans, I have this all the time, where veterans don't apply until 15, 20 years after service. And yeah, we get them service connected, and yeah, we get them VA disability at a great percentage rate. But then they look back and they go, did I just seriously miss out on a decade's worth of VA disability because I didn't appeal or I didn't apply right away? So again, this is not to scare anybody, but if you get a rating decision from the VA and you disagree with it, go back, find somebody, get some help, and appeal that decision if it's not correct. If you want to hire me or my firm to help you out, the way you do that is by scheduling a consultation. You can reach out to us through a link that's in the description or by calling our phone number or going to the website. Lots of ways to reach out to us. Let's see if we can help you on your VA disability benefits appeal. If you have any questions, though, or you want to see more content like this, comment on this video, hit like, subscribe, reach out to us, and we'd love to hear suggestions from viewers on content. Whatever we can do to put the information out there to help veterans, because I know a lot of you won't even hire me, and that is perfectly fine. If you watch this video, get some good tips, and you get the rating you believe you're entitled to, great. So please keep the comments coming, keep the suggestions coming, share this video with others, like, subscribe, do what the other YouTubers on YouTube tell you to do, because they're better about YouTubing than I am. I'm just a lawyer who likes to put stuff out there. Anyway, until next time, take care.